This podcast is brought to you by the School of Advanced Study, University of London.
Okay, I'm going to shake things up here a little bit and give you some pictures. Both partly to help with staying awake in that awkward post-lunch period, and partly because I'm going to do some of my talk through graphs and charts and things that portray some of the messages of some of the colonial legacy easier than perhaps words do. So I'd like to speak briefly about the legacy of British colonial sexual offences laws in the Commonwealth, and the impact, the continuing impact, and often very pernicious impact that those British colonial laws are still having in many parts of the world. I'll just go through a few of the examples of the types of provisions that I'm going to speak about. Rape, of course, is a standard provision in any criminal code, and this is the way some of them are worded. Any person who has unlawful sexual intercourse with a woman or girl, sometimes adding who is not his wife, without consent or by force, etc., is guilty of rape. And then there's some maximum punishment set, which is often life. And what I want to focus on there is simply the emphasis on unlawful sexual intercourse with a woman or girl. So these are sex-specific rape provisions, and in some cases providing express exemptions for husbands. There's also commonly a provision on defilement of girls under a certain age. So any person having, again, unlawful sexual intercourse with a girl under a specified age is guilty of a felony and subject to a certain maximum term of imprisonment. And then there's a third category of offences, indecent assaults, which again, in many cases still, from the British origins, are sex-specific. So any person who unlawfully and indecently assaults a woman or girl commits a felony and is liable to imprisonment. And in some cases, offences to modesty, which again apply only to females, where any person who, intending to insult the modesty of any woman or girl, utters any word or makes a gesture or invades the privacy of such a woman or girl, commits usually a misdemeanor with a lower term of imprisonment. So the point there is simply that these offences were crafted and still continue, despite changes here, to be sex-specific offences that separate out the types of offences that can be committed against females from those that can be committed against males. So the English common law was focused on various things in respect of these offences. Often it was focused on the character and sexual history of the woman, so the woman's character often, of course, ending up on trial rather than, or perhaps more so than the alleged perpetrator. Often the need for clear physical proof of the crime, the need for a prompt complaint, and presumptions being drawn if a prompt complaint wasn't made. And often the need for corroborating evidence, so the corroboration rule that lived till quite recently, even here until 2002, that required that in order to convict, there needed to be corroborating evidence, which of course in sexual assault cases is difficult, if not impossible. And it was based on the notion that women's testimonies were inherently unreliable and should not be taken without corroborating evidence. That, of course, that rule was changed by the Privy Council in R. and Gilbert in 2002, where the Privy Council said that the corroboration warning in sexual offences cases is a matter of discretion for the judge. Another element of the historical concept of sexual offences laws was that there was no such concept, and indeed an impossibility, of rape in marriage. And the famous statement by Sir Matthew Hale in 1736 that the husband cannot be guilty of a rape committed by himself upon his lawful wife, for by their mutual consent and contract the wife hath given up herself in this kind unto her husband, which she cannot retract. So the notion that a man might rape his wife was simply an impossibility. that concept remains in several legal codes, penal codes around the Commonwealth and in the common law. And sometimes you'll find provisions along these lines, sexual assault by a husband in certain circumstances. So a husband commits the offense of sexual assault when he has sexual intercourse with his wife without her consent, by force or fear, where, and only where, there is in existence in relation to them a decree nisi or a judicial separation or a court order. So in other words, it's only where that contract has effectively been withdrawn that the wife has any control over her own body. And that also implicitly implies that so long as a woman is married, their sex by force or fear is perfectly lawful. That, unfortunately, was also spread around the Commonwealth, and for example, in jurisdictions that inherited the Indian Penal Code of 1860, so Commonwealth Asia, laws expressly exempt husbands from prosecution. And then in other countries, we have these types of provisions that only exempt or provide that there can be such a thing as marital rape where there's a judicial separation of some kind. And we still see cases, for instance, as recently as last month, May 2014, an Indian case where a judge ruled that sexual intercourse between a husband and wife, even if forcible, is not rape. Another aspect of sexual offences laws that continue to persist around the Commonwealth come under the category of unnatural offences, a term coined in Victorian times, and provisions along this line exist in many countries still. So any person who commits buggery with another person or with an animal, those are lumped together, and any person who permits a male person to commit buggery shall be guilty of a felony. And we'll come back to the terms of imprisonment in this example, and this is relatively common. A maximum term of imprisonment is of 14 years. But what we notice there is that there's no element of consent required. So whether it's with or without consent, there's no reference to the age of the parties, and there's no reference to whether it's a public or a private act. Similarly, there are some provisions that continue to exist around the Commonwealth on indecent practices, usually just between males. In some cases, countries have tried to equalize their laws by applying these to females as well. Hopefully that's not the version of equality that we want to have, but the provision provides that any male person who, whether in public or private, commits any act of gross indecency with another male person is guilty of a felony. And that provision was enacted by the 1885 Criminal Law Amendment Act, intended to capture forms of sexual intimacy between males that was something less than penetrative sex. So any sort of sexual intimacy. And the idea was to try and capture more easily these offenses, given that it would be relatively difficult to prove in cases of private consensual conduct between two adult males that a crime had been committed. So the law sought to expand its reach by making it easier to criminalize any form of intimacy that might more easily be proved. So the result, and here come the pretty pictures, which I hope will give the picture around the Commonwealth today. Rape still only applies to females, female victims, in 26 out of 53 Commonwealth countries. So just over half still only have rape as a concept that can be committed against a female victim. In a slightly less number of countries, but still 19 out of 53 countries have non-gender neutral sexual assault laws. So those indecent assaults are something less than rape, but a sexual offense of some kind. So still quite a bit of sex-specific laws rather than gender neutral laws. Another aspect is related to women's bodies being marital property. So whether marital rape is criminalized, we still have only 45% of Commonwealth countries where it is a crime for a husband to rape his wife, even if it's by force. In 41 out of 53 Commonwealth countries, non-penile vaginal sex is criminalized, regardless again of consent or location or age of the parties. So these are variously termed the abominable crime of buggery or carnal intercourse or carnal knowledge against the order of nature between males, that type of thing. So almost 80% of the Commonwealth still has these colonial legacy laws that were passed around in the 19th century. One of the things that means is in the sphere of crime and punishment is that where there is a rape of a female and a rape of a male, the crimes or the punishments remain different. So you'll recall we saw that the maximum sentence for rape is often life or as high as life. For buggery, whether it's consensual or not, it might be 14 years. And there's that conflation between consensual and non-consensual. So a male victim of rape, falls under the simple buggery law rather than the rape law. These are the differences in penalties around the countries that have those differences. So you'll see the red or pink bar is the maximum sentence for a female victim, and the green is a male victim of non-consensual buggery. So the penalties are quite starkly different. So the focus at the time that these laws were spread around the Commonwealth was on male control over women's lives, including their bodies, and the notion that once a woman entered into a contract of marriage, her rights effectively became subsumed in that of her husband, including over her own body and physical integrity. And the notion that there was property damage when women were violated, the property of the husband or the father was damaged when a woman was sexually assaulted. And also a general focus on non-procreative sex being immoral, and therefore this within the sphere of the law to criminalize, rather than, as we hopefully would all agree today, the focus should be on equality of women and men, the autonomy of the individual over his and her own life and certainly body, and a focus on the rights of victims. This map is from our website at the Human Dignity Trust, and it maps the countries that criminalize homosexuality. And if you just sort of make a mental note of where they are, it's the MENA countries down through Eastern and Southern Africa, certain parts of West Africa, and then down through the Indian subcontinent, the Pacific Islands, and certain parts of the Caribbean. And if we look at a map of the British Empire, you'll notice quite a bit of similarity. So again, the countries that were colonized or dominions of Britain, and of course a few more are on the list, or off the list now, having decriminalized. Australia, obviously, Canada, the so-called old Commonwealth have decriminalized. But that map maps quite a bit with the countries that still today criminalize homosexuality. So again, just in terms of statistics, there are 53 Commonwealth countries, as we know. That's just over 25% of all countries in the world, and yet they represent over 50% of the jurisdictions that criminalize homosexuality, almost 80%. And these laws originate from the 1861 Offences Against the Persons Act, which related to sodomy. Of course, those laws go all the way back to 1533, when the death sentence applied to sodomy, and of course even before that to canon law. But it was the 1861 Offences Against the Person Act that was in place at the time of the colonial project, and therefore spread around the Commonwealth. And gross indecency, as I said, was added in 1885. And just to juxtapose that against the other European empires and colonies, Napoleon's French Penal Code of 1810 informed both the French legal system and most of the other European powers at the time. And so most of those countries and the colonies that they had as part of their empires never criminalized homosexuality. Similarly, the French Penal Code of 1810 had gender-neutral rape and sexual assault laws. As early as 1810, it explicitly said rape of either sex, and indeed even the offences against modesty related to either sex. So it was already gender-neutral in the early 19th century, and therefore those are the laws that were spread around those colonies. I'm just going to very quickly go through a few charts that show the impact of that particular law on homosexuality. So the countries that criminalize are the green ones. So if you look at the British colonies of South America, it's a much larger percentage, and none in the other European colonies. Same in the Caribbean. It's none of the non-Commonwealth countries, the other European powers, and most of the British former colonies. Same in Africa, similarly in Asia, and also in the Pacific. So it's a very clear link between the former legal history and the current status today of these sexual offences laws. So in conclusion, the implications obviously are that we have sexual offences laws that are based on the subordination of women in relationships, that are based on offences against the morality of religious dogma or of societal views, rather than a focus on the rights of victims. And that's seen where we have a rape victim that's male being treated differently as a rape victim that's female. And various actions that are being taken around the world are now trying to deconstruct these old British colonial laws through either repeal, which has happened in a number of countries, or more commonly through the courts that happily have the benefit of the Magna Carta inspired, I suppose, but post-independence constitutions that contain bills of rights that we hope at least apply to all, including women and LGBT people. Thank you.